right, we're going to cover a lot of good material today. I hope you guys can hear me all right. Just give me a thumbs up if you can hear. The sound quality's okay. I've got a microphone hooked up. Just don't know if you guys can hear me or not. Get a thumbs up if you can hear me. Loud and clear, not distorted or muffled. All right. The birth certificate is a trust. The most common question raised by people who are exposed to the trust theory is whether the birth certificate is in fact an express trust as we allege. It is a valid question and deserves a thoughtful answer. The Uniform Trustees Power Act, UTPA, go ahead and write that down, Uniform Trustee Powers Act, regulates express trusts that are created by trust instruments, CORS 128.0051. The trust, not necessarily the trust instrument, must provide that a trustee has the duty to administer a trust asset for the benefit of the named or otherwise described income or principal beneficiary, or both. UTPA specifically exempts constructive trust from its regulations. An express trust can be a trust that is created by the direct and positive acts of the parties, by some writing impliedly evidencing an intent to create a trust. Black's Law Dictionary. Some confusion arises because the birth certificate appears to establish a constructive trust. A constructive trust, see Black's Law Dictionary, is one raised by construction of law or arising by operation of law as distinguished from an express trust. The main proof against that argument is that a constructive trust, like a resulting trust, is abstract, not written obviously. The birth certificate is a writing. Curiously, fraud, active or constructive, is the essential element of constructive trust. Black's Law Dictionary. The fact that the birth certificate is a written instrument does not in itself make it a trust, but that is one of the essential elements of an express trust that we can eliminate. Other elements are that the trust provided that a trustee has the duty to administer a trust asset for the benefit of a named or otherwise described income or principal beneficiary, or both. If you've examined our article, which document that the United States was bankrupt in 1928 through 1932 and has since been in a condition of receivership, you know that the state, which is named on every birth certificate, is both an income and the principal beneficiary of every citizen. Even if you do not yet possess that knowledge, you certainly are aware that the state claims a legislatable interest in every child within its jurisdiction. You may not be able to cite the statutes, but you know the state will, if it is deemed necessary, nullify your parental rights and appoint a guardian trustee over your children. The United States pledged the full faith and credit of the United States, including its citizenry, as collateral for loans of credit from the Federal Reserve System. Each of us, including our children, are assets of the bankrupt United States. We are human resources, and the state has repeatedly claimed that our children are our most valuable resource. The subject of each birth certificate is a child. The child is a very valuable asset which, when properly trained, can be milked of its labor for many years. The child itself is the asset of corpus of a trust established by the birth certificate. The mother or parents are appointed during good behavior to serve as trustees for the asset. Her or their names appear on the trust instrument. They are required to see to the child's care, feeding, shelter, and education. Should they default in their duties, the state will appoint other trustees. The duties incumbent on parents are explicitly spelled out, not only in the Uniform Trustee Powers Act, but throughout every state statute. All of the elements that are necessary to establish an express trust are expressed or implied on the face of every birth certificate. The asset or corpus of the trust is named and described, the child. The trustees are named and described. The income and principal beneficiary is named. The trustee's administrative duties are implied, but are commonly understood. The instrument establishes a trust where none could exist before the live birth of a new citizen. The birth certificate does indeed create a trust. As the child matures, the trust may acquire other assets, such as income, inheritance, gifts, etc. When he reaches maturity, he will assume trusteeship over the remaining corpus of the trust and will have a duty to administer the assets and income for the benefit of the state. Typically, he will merge with another trust, the issue of which will be willed via birth certificate to the state. And, God willing, and the creek don't rise, the cycle of slavery will repeat itself ad infinitum. I hope this answers some questions instead of raising them. Certificate, a document in use in the English Custom House. No goods can be exported by certificate except foreign goods formerly imported on which the whole or a part of the customs paid on importation is to be drawn back. Wharton. Date June 11, 1993, Mr. Bill Conklin, care of NCBA, P.O. Box 225, Longmont, Colorado, 80502. Dear Bill, regarding your $50,000 reward offered in the May 1993 NCBA reports, if I can show you, 1, what statute makes you liable to pay an income tax, and 2, how you can file a tax return without waiving your Fifth Amendment protected rights. Are those intended to be a trick question? First, as I believe you are aware, no one can pay a debt or obligation when the only money generally available is monetized debt. The best one can do is to discharge the debt or obligations. For purposes of this letter, I am going to assume you are asking what statute makes you liable to discharge an income tax. But we need not to be too picky on this point, since legislators have redefined the term pay. They use it in statutes to mean discharge. Second, you do not provide enough information to enable anybody to answer your first question. How many dollars of income do you manage for the William Conklin Trust? If it is less than the minimum required for filing a return, you are not liable to discharge an income tax. But if it is above that minimum, assuming you are a resident of Colorado, you will find the statute that makes you liable to pay an income tax in the Colorado statutes book. In Oregon, the statute is ORS 128.009. If you will look up the Colorado Uniform Trustees Power Act, you should find a virtually identical statute as this, ORS 128.0093T. A trustee has the power, subject to subsection 1 and 2 of this section, to pay taxes, assessments, compensation of the trustee, and other expenses incurred in the collection, care, administration, and protection of the trust. Exercise of all the powers granted to an Oregon trustee is made mandatory by ORS 128.0092, which provides in the exercise and of power, including the powers granted by ORS 128.003 to 128.00051 and 128.0565, a trustee has a duty to act with due regard to obligations as a fiduciary. All Oregon trustees are fiduciaries for the state, the United States, the International Monetary Fund, and United Nations organizations. I think I can safely presume that residents of Colorado are bound by the same obligations under that state's Uniform Trustees Powers Act. And you have contracted to adhere to all of the applicable laws of all of those organizations. So much for the statute that makes you liable. As to your second question, since the trustee, while exercising his power and duty to pay the tax for the trust, has no right contemplated by, expressed in, or protected by the Fifth Amendment, he and you cannot waive that which he does not possess. I am enclosing a 3-page article which supports the above in very general terms. I strongly suggest that you and all of your friends and associates seriously consider the relevance of trust to the income tax and virtually every other freedom movement issue. Your offer in its present terms cannot be claimed by anyone. As you know, over the years, several patriot types have made very similar offers. You'll probably be the first to admit it. It is a publicity promotional gambit. What's interesting, whether you were aware of it or not, is that the dual question are riddles. Riddles invite people to focus their attention on seemingly obvious but irrelevant matters. In this case, they focus on Title 26, the 16th Amendment, and the 5th Amendment when the solutions are outside that spectrum. With your vast experience with the IRC code, etc., you can continue to bind the attention of freedom seekers to the IRC code until they drown in it. Or you can determine exactly what makes so many people liable to labor for their own enslavement and begin to help lead them, if they can be led, out of the morass we are collectively wallowing in. Whatever you do, Bill, I wish you the best. Yours truly, James Hazy. False assumptions, birth dates. Acting on false assumptions instead of on facts assures that our actions will lead us into unintended obstacles. You cannot reach desired goals by taking the wrong path. In no case is this more apparent than in the matter of dates of birth. Make the wrong assumption and you will grovel in inescapable slavery. Act on the facts and you will set yourself free. Here are some facts that are relevant to the subject of dates of birth. Like many other words, birth and date have precise legal meanings which, if not fully comprehended, will lead us into great trouble. Through long training, habit and repetition, we come to associate our date of birth with that day, month, and year on which we squeezed kicking and screaming from our mother's womb. It's been a bad habit with terrible consequences for most of us. That day of our natural entrance into the world is not the birth date of the person named on the birth certificate. We have been suffering under a false assumption. It's high time we correct that error. Bovier's Lowell Dictionary, 1867, defines birth as the act of being wholly brought into the world. In expanding on this succinct definition, Bovier's remarks restrict the legal meaning to the subject of actual physical childbirth. It goes without saying that a lot of water has passed under the bridge since Bovier's penned his authoritative definition of birth. The forms of government have been radically altered, and in many instances, words have been assigned different meanings. Sometimes the differences are subtle, sometimes extreme. Today, Black's Law Dictionary, 5th edition, defines birth to appear deceptively similar to the definition given by Bovier's. Black's Law Dictionary defines birth as the act of the being born or wholly brought into separate existence. The careless observer will discern no significant difference between the definitions given by Bovier and Black, but the differences are very significant. Bovier does not provide a definition for born, but if he had, we can discern from his definition of birth that he would define born as describing a human birth. Black's Law Dictionary does provide its definition of born to mean act of being delivered or expelled from mother's body. Black's Law definition for born is essentially identical to Bouvier's definition for birth. This is also Black's first of two definitions for birth. And, like Bouvier's, Black's first definition of birth describes a human birth. But Black's law definition continues in his definitions of birth, providing a different alternative definition, or the act of being wholly brought into separate existence. There is a subtle but significant difference between Bouvier's brought wholly and Black's wholly brought. In the case of Bouvier's dictionary, wholly describes the total extent to which one comes forth and separates from the womb, that not just parts of the new creature have existed and taken on separate existences, but all of him. This refers only to a natural child being. Black's law dictionary uses wholly to describe the extent of which generic entity, not a human being, is deemed to have experienced birth. Birth, by Black's second definition, requires that the subject be completely and totally brought into existence. The difference between wholly brought and brought wholly is something of a brain teaser, but meditate on it, and the difference will come to you. Bouvier's refers to the child being brought into the world, the connotation being that something real and substantial observed by the senses has arrived on the planet. Black's brought into separate existence can easily include a legal fiction or other artificial entity, such as a name, person. A good example would be a corporation, an artificial person. So far, our inquiry has established that in modern legal jargon, birth can mean the delivery of a human child or the act of bringing into full and complete existence an artificial entity. We find similar games played with the word date. Bouvier's defines date to mean the designation of indication in an instrument of writing of the time and place when and where it was made. More, written instruments generally take effect from the day of their date, but the actual day of execution may be shown, though different from which the instruments bears. Black's law convenient definition of date does not include the place where the instrument is executed. The specification or mention in a written instrument of the time, day, month, and year when it was made, executed, parentheses in original emphasis is mine. Black's law defines executed as completed, carried into full effect, already done or performed, signed, taking effect immediately, now in existence, or in possession, conveying an immediate right of or possession, act or course of conduct carried to completion. Term imports idea that nothing remains to be done. The place at which a written instrument is executed is of extreme significance to its effect. For example, a statute enacted by the California legislature may have great effect on the lives of Californians, but none on Oregonians. By deleting place as an element of the definition of date, Black's The Official Lawyer's Dictionary minimizes the importance of place while diverting attention away from its significance. The birth certificate, the source of all enslaving adhesion contracts, the birth certificate creates an artificial entity. In the beginning, that entity is merely a name, attached to which are other names of state-certified parents, doctors, informants, and places. The certificate is a written instrument created by a registrar, the state registrar to be exact, who is an employee agent of a jurisdiction, of the place in which the certificate is created. Neither the registrar nor his principal created the human baby, who is merely grist for the certifying process. The only thing bureaucrats can create are artificial entities and legal fictions. A birth certificate is executed by signing, filing, and recording it, which constitutes the act of wholly bringing the certificate and the artificial entity it creates into separate, distinct, unique being. The subject matter of the written instrument certificate is the live birth of an infant, but it is not the live birth that is executed by signing, filing, and recording the certificate. That had already been accomplished, usually several days before the filing, by conception and gestation, consummated by a child being born. Neither the state nor its registrar had anything to do with executing the live birth of the child. Hence, mom is the grantor. The date, specification in the written instrument of the time when it was executed is the day, month, and year on which the certificate was signed and filed, i.e., the time it executed when the official name, artificial entity, record mentioned in the certificate was wholly brought into separate existence. In other words, the Black's Law Dictionary second definition, the date of birth of the record entity. Natural possession, or natural person, real live flesh and blood people, have birthdays which commemorate anniversaries of their being brought wholly into the world. They do not have birth dates. Only state certified names have birth dates. Dates of birth. There is nothing about these dates in the nature of commemoration or memorial, nothing happy, sad, or otherwise emotional about them. Such dates of birth are merely cold, dispassionate facts which testify to the time and place of birth of the certificate, except when he is applying for a benefit that is made available only to artificial state-certified persons. An individual is free to go by any name that pleases him. He is under no legal or moral compulsion to use the name attributed to him on a birth certificate. However, if he uses that name or a similar variation of it, he should be very careful in separating the two. The natural and artificial creature, he must remember, he is not the name and the name is not him. The artificial is the clone of the child man public estate. For example, when he is acting as attorney for the artificial being, he should provide its birth date when required by business dealings. Alternatively, when he wishes to enjoy the right inherent in natural individuals, he will want to distinguish between dates and days, and never state that his birth date is the same as his birthday. The safest course is to avoid situations such as applying for or using benefits, where the giving of a birth date may be innocently construed as intent to obligate the natural person. Not too many decades ago, birth certificates were generally perceived as innocuous and harmless. Most people believed them to be beneficial in that they established reliable records for genealogies and assisted in expediting inheritance, probate matters, and the like. Few people were alarmed by sinister implications surrounding birth certificates or the potential for abuse inherent in them. It was this very absence of fear or concern that permitted them to eventually be used against us. Nobody was watching. Nobody was warning their children about the danger of birth certificates. Nobody was educating the people on how they could be used as government weapons against the people, or how the people could defend themselves from such assault. And today, most people still believe that the birth certificate are harmless and beneficial. The danger with the birth certificate is that, with just a little indoctrination by the parents and government schools, most people confuse the two entities involved, natural person and artificial person. They do this primarily as a result of being trained from childhood to believe the date of birth is synonymous with the day of birth. After a while, most people cannot distinguish between the name and their mortal being. They say, "I am John Smith," more frequently than they will say, "My name is John Smith." It is this indoctrinated inability to distinguish between the two that gets people in serious trouble. They enter into adhesion contracts with government agencies that strip them of their ability to exercise natural rights and obligate them to all manner of demeaning servitude. Black's definition adhesion contract as a standardized contract form offered to consumers of goods and services on essentially take it or leave it basis without affording consumer realistic opportunity to bargain, and under such conditions that consumer cannot obtain desired products or services except by acquiescing in form contract. Distinctive features of adhesion contract is that weaker party has no realistic choice as to its terms. An intractable system of governance has developed by which it is made difficult for the natural person to exist, much less thrive, except he contract with the government agencies. Adhesion contracts seem to be required of him to own and drive a car, own or rent property, acquire food, gasoline, and the most critically, to obtain the government Federal Reserve notes, cash, necessary to secure these benefits. Every such benefit is made available only to artificial state-certified persons. To prove that one is eligible for the benefits, he must produce a birth date and often even the certificate instrument that certifies the date given it is accurate. Do you see what happens? The contractor provides not the date of birth of the certificate, but his birthday. The bureaucrat never argues, even though the face of the certificate proves the applicant is lying. The customer is always right. The bureaucrat merely pushes the adhesion contract across the counter for the applicant's signature. The contract is executed, and the natural person who, by association with the date of birth of an artificial entity, binds and obligates himself to whatever erroneous specific performance will be required of the contractor. By submitting a birth date, the contract adheres to the helpless individual. Invariably, one condition of such contracts is that, should any controversies arise, the applicant agrees to let the matter be arbitrated in the company courts. Neither natural rights nor constitutional rights are issues, nor are they permitted expressions in such courts. Stop being a slave. Get yourself free. Don't confuse the birth date with the day on which you were born. They are never the same. Clean up your act, since you probably cannot remember every instance in which you innocently provided a wrong birth date to receive a benefit. Publish a public apology and retraction. Set the record straight. Send copies of the notice to the business you remember dealing with, such as the IRS, Social Security Administration, and DMVs, and good luck. Black's Law Dictionary, subject date of birth. Birth, the act of being born or wholly brought into separate existence. Date, the specification or mention in a written instrument of the time, day, month, and year when it was made, executed. Also, the time so specified. Birth date, date of birth, is the time entered on the birth certificate which specifies when the registrar signs certificate, the written instrument. Execution is effected by the act of signing. Signing execution is the act that wholly brings the certificate into separate existence. It is indeed separate from the natural person, infant, whose name is mentioned on it. Perhaps now you see how you can accomplish the objectives as laid out in much simpler manner. Did you consent to these shenanigans knowingly? When we come back, we're going to get into a general power of attorney. But before we leave, I want to share something great with you. And I want you to get out a pen and a paper and go ahead and write this down. some people would appreciate it if I probably wouldn't divulge this to you, but I'm going to anyway. And the reason for it is that it is important, okay? I, Lisa Wilder Leach, being of sound mind and of the age of whatever age she is, as grantor of the private trust security estate, Derek Chaton Gonzalez, registration number, which is the birth certificate number, date of registration, which is the date of registration number, do bless and do grant irrevocable power of attorney over said trust security to my son, Derek, his agents and or assigns this 20th day of October, 2019. Your mom signs it. Signed before me at the municipality of Valley County, whatever you want to do, or the municipality of Ord, in the county of Valley, state of Nebraska, this 20th day of November, 2019. Now, you may ask what the significance of what I just articulated to you is. Well, your mother is naturally the grantor, and she made a special trust deposit, but she didn't realize what she was doing, okay? And the only way to take control of that estate is to have the grantor give an assignment, and that assignment is power of attorney to you, all right? And once you have that, you can do something similar to what I have done, which is this. General durable power of attorney. The special grant of authority replaces and supersedes all prior powers of attorney by donor principal, Derek Chaton Gonzalez, Derek S. Gonzalez, Derek Chaton, or any such combination or representation of letters representing donor. Do hereby nominate, ordain, and appoint donee, agent, Gonzalez, Derek Chaton, as called by parents, Jose Gilmore Gonzalez and Lisa Wilder, in care of 1005 O Street, Ord, Nebraska, 68862, no phone number. Be my attorney in fact and executor general with authorities to writ. This power of attorney is effective immediately. Release of information. I agree to authorize and allow full release of information by any governmental agency, business, creditor, or third party who may have information pertaining to my assets or income to my agents named herein. Grant of general authority. I grant my agent and any assessor agent general authority to act for me with respect to the following subjects as defined in the Nebraska Uniform Power of Attorneys Act: real property, tangible personal property, stocks and bonds, commodities and options, banks and other financial institutions, operations of entity or business, insurance and annuities, estates, trust, and other beneficial interest, claims, and litigation. Personal and family maintenance, benefits from government programs or civil or military service, retirement plans, taxes, and I grant my agent and any successor agent general authority to do all acts that I could do or do through an attorney, and grant my agent's authority to exercise a presently exercisable general power of appointment held by the principal, and this power of attorney is not affected by lapse of time, subsequent disability, incapacity, or incompetence of the principal, and remains effective should principal suffer any subsequent legal incapacity, and grant of specific authority. I grant my agent and any successor agent general authority to act for me with respect to create, amend, revoke, or terminate an inter vivius trust, make a gift with which exceeds the monetary limitations of the Section 217 of the Uniform Power of Attorney Act of the Nebraska Uniform Power of Attorney Act, create or change rights of survivorship, create or change beneficiary designation, delegate to another person to exercise the authority granted under this power of attorney, waive the principal rights to be a beneficiary of a joint and survivor annuity, including a survivor benefit under a retirement plan, exercise fiduciary powers that the principal has authority to delegate, renounce or disclaim an interest in property, including a power of appointment and a personal finance to withdraw and deposit funds from bank accounts belonging to principal and to enter and remove the contents of all safe deposit boxes rented by the principal, to ask, demand, sue, for, recover, collect, and receive each and every sum of money, debt, account, legacy, bequest, interest, dividend, annuity, and demand which now is or hereafter shall become due, owing, or payable, belonging to or claimed by principal, and to use and take any lawful means for the recovery thereof by legal process or otherwise, and to execute and deliver a satisfaction or release thereof, together with the right and power to compromise or compound any claim or demand, to borrow money and to execute and deliver notes with or without security, and to loan money and receive notes with such security as attorney in fact shall deem proper. B, real property or any interest therein or any improvements thereon, to contract for, purchase, receive, and take possession thereof, and of evidence of title thereto, to lease the same for any term or purpose, including lease for business residence, to sell, to exchange, subdivide, grant, or convey the same, with or without warranty, covenant, or restrictions, to mortgage, transfer, and trust, or otherwise encumber the same to secure payment of a note or performance of any obligation or agreement. C, personal property, to contract for, buy, sell, exchange, transfer, endorse, negotiate, and in any legal manner deal in and with the same. And to mortgage, transfer, in trust, or otherwise encumber the same to secure payment of a note or of performance of any obligation or agreement. D, business transaction of any kind, and as the act and deed of the principal to sign, execute, acknowledge, and deliver any deed, lease, assignment, or lease, covenant, indemnity, agreement, mortgage, deed of trust, assignment of mortgage, or beneficial interest under deed of trust, subdivision or plat, extension or renewal of any obligation, subordination, or waiver of priority, bill of lading, bill of sale, bond, note, receipt, check, evidence of debt, full or partial release of mortgage judgment or other debt, and such other receipt, check, evidence of debt, full or partial release of mortgage judgment of other debt, and others instruments in writing of any kind or class as may be necessary or proper in the premise, to do and perform every and all of any acts required, necessary, or appropriate to be done in and about the premises as fully to all intents and purposes as principal might or could do if personally present, hereby ratifying all that attorney in fact shall lawfully do or cause to be done by virtue of this general power of attorney, F, excuse me, I'm losing my voice today. All right. And authorize another person to exercise the authority granted under this power of attorney, and limitations on agent's authority. An agent that is not my ancestor, spouse, or decedent may not use my property to benefit the agent or a person to whom the agent owes an obligation of support unless I have included that authority in the special instructions, except for any special instructions given herein to the agent to make gifts. The following shall apply. A, any power of attorney granted to my agent herein shall be limited so as to prevent this power of attorney from causing any agent to be taxed on my income or from causing my assets to be subject to a general power of appointment by my agent as defined in 2038, 2041, and 2514 of the Internal Revenue Code of 1986 as amended. And B, Agent is not required to be bonded per Title 26 U.S.C. subsection 2032 AE11 with the Secretary of Treasury of Puerto Rico. Successor nominee agent is Lisa Wilder Leach, biological mother, in care of 10050 O Street, Ord, Nebraska 68862. Nomination of conservator and guardian. Should it be necessary for a court to appoint a conservator or guardian over my estate or guardian of my person, I nominate the following person for conservator and guardian appointment over my estate, and person is donee or successor if donee is incapacitated at 1005 O Street, Ord, Nebraska 68862. A copy of this instrument shall have the same force and effect as the original. All right. And this was done June 14th, 2021. And later on, we'll get into the license grant deed and the importance of the license grant deed. That was the general durable power of attorney. We'll get into this instrument real quick. And this is the registration of memorial of outstanding certificate of title in the style of an affidavit. Affiant is familiar with the facts recited in the outstanding Arizona certificate of title, and I give the number, and the party named in Arizona certificate of birth is the same party as one of the owners named in the Arizona certificate of birth. However, this affiant is true bailer of Arizona certificate, and IMF account number, which is the social number, is tied to the estate in Arizona certificate in which I, the affiant, am a security entitlement holder. Witness my sigil and seal. Sigil and seal being my thumbprint, my toe print, all that good stuff. And so we've memorialized that. We've created a public record. We're letting them all know that we have control of this. All right, it's ours. And later on, we'll give I'll do a class and I'll show you guys how to do all this. All right, and this becomes very important with what I'm doing with the court system right now. And we'll get into that a little bit later. So thanks for joining me. Thanks for supporting selfgovernanceU.com. And I hope this video helps you out a lot.